Hello everybody, welcome back to the channel, the Butterfly Monkey Effect channel. I've been a little procrastinating and a little bit busy too, writing up some other paperwork, so I haven't gotten back to this. But today will be a continuation of commercial law, specifically the book by Lavine, the manual. This is of course the national edition. Last time we left off right here, part C, part 1. It's part 1, section C of this. So to continue, governmental powers and limitations. 49. Force essential to law. Without the force of authority, law would be a mere collection of rules. Hence, the supreme power in a state not only prescribes rules of civil conduct, but enforces them. The organization of this supreme power is government. Dual sovereignty, delegation of authority. Our system of government represents a dual sovereignty. The states, originally sovereign, have by the United States Constitution delegated certain paramount authority to the United States government, reserving to themselves all sovereign authority not thus delegated. Hence, each state, while sovereign, is subject not only to its own constitution, but also to the United States Constitution, which is the supreme law of the land. Under each state constitution, governmental power may be further delegated to subordinate units for local government, such as counties, cities, towns, and villages. Such delegated authority is circumscribed by constitution, statute, and charter. For example, in determining the validity of a municipal bond issue, we must ascertain whether the delegation and exercise of sovereign authority are within constitutional limits, whether the municipality was authorized to issue the bonds for the purpose under consideration, whether the debt limit has been exceeded, whether the preliminary steps required by law have been taken, whether proper provision has been made for the payment of the bonds, whether the bonds are in the proper form, whether they have been duly executed and delivered by the proper officers, and whether they have been sold or disposed of in accordance with law. I'm sorry. I've been eating a lot of hot peppers. I ate one, 10 minutes ago. It's still lingering. Constitutionality. Any act of Congress which fails to conform to the United States Constitution and any state statute or municipal ordinance which fails to conform to both the federal and state constitutions is unconstitutional and void. It is therefore a paramount importance that we understand that basic framework of the Constitution of the United States. Basic framework of Constitution. The Constitution of the United States does three things. It prescribes the form and specifies the powers of the government it creates. 2. By way of guarantee and safeguard, it limits the powers not only of the government it creates, the federal government, but also in certain respects the states themselves. And 3, it provides for amendments. Every act of Congress must find its authority in these powers. Every act of government, federal, state, or local, is subject to these limitations. Constitutional powers and functions. The Constitution distributes all federal powers and functions into 3 separate departments: executive, legislative, and judicial. For any of these departments to transgress the others is to violate the Constitution. Congressional powers in general. Congress may raise money by taxation and duties on a uniform basis throughout the country, borrow money on credit, regulate commerce among the states and with foreign nations, establish uniform rules on naturalization, enact bankruptcy laws, coin and issue money, and punish for counterfeiting, fix standards of weights and measures, establish post office and post roads, enact a copyright and patent laws, establish federal courts inferior to the United States Supreme Court. Hope you guys understand what he just said here. Establish federal courts inferior to the United States Supreme Court. Right? These courts are going to be legislative courts, the Article 1 courts. Punish for crimes committed on the high seas and acts in violation of international law. Declare war, raise and support armies, provide and maintain a navy, govern the district, which is the seat of government, District of Columbia, and make all laws necessary and proper for carrying into effect the foregoing powers. Constitutional powers, valid exercise. Every act of Congress must fall within a framework of its specifically delegated powers. For example, provisions for corporate reorganizations, Section 1350, and for individual and corporate arrangement, see Section 1353, fall within the power given to Congress to enact bankruptcy laws. The following acts of Congress were passed under its constitutional power to regulate interstate commerce. Before we keep going, I want to go to this part. So corporate reorganizations and for individual and corporate. So 1353. I'm guessing that's this book. And that's going to be the statute too. So 1353. Let's see what he's talking about in terms of individual and corporate souls. It's dealing with the bankruptcy stuff. Compositions, arrangements, and common law settlements distinguished. Let's read this real quick. I think it might be important. 1553 was what we were looking for, right? The definition and purpose, extension of debtor relief. An arrangement is defined by the Bankruptcy Act as any plan of a debtor for the settlement, satisfaction, or extension of the time of payment of his unsecured debts upon any terms. The provisions for arrangements embodied in the present Bankruptcy Act are an outgrowth of emergency relief provisions adopted by Congress in 1933, whereby debtors were given an opportunity to work their way out of their financial difficulties without the stigma of bankruptcy by judicially controlled composition or extension agreements. Chapter 11 of the Act is designed for ordinary debtors. Chapter 12 for real property arrangement. Chapter 13 for wage earner plans. I'm not going to read this, but arrangements are brilliant. Alright, so I'll probably end up reading this chapter. Back. Yeah, it was 1553. It says the following acts of Congress were passed under its constitutional power to regulate interstate commerce. The Sherman Antitrust Act of 1890, which declared every combination and restraint of trade illegal. Clayton Act 1914, which was designed to strengthen the Sherman Antitrust Act and which established the Federal Trade Commission to investigate unfair business practices and check monopolistic tendencies. Patman Act, 1936, intended to straighten and supplement the Clayton Act by making it unlawful directly or indirectly to discriminate in price between buyers, large or small, for commodities of like grade and quality. The Tidings-Miller Act, 1937, which modified the Sherman Antitrust Act by legalizing resale price maintenance agreements upon certain conditions. The Securities Act of 33, which was designed to accomplish two objectives: to provide full and fair disclosure to prospective investors of the character of new securities or new offerings, and two, to prevent fraud or misrepresentation in the sale of securities old and new. The Security Exchange Act of 34, which was adopted to establish federal regulation over securities exchange and markets. 2, to prevent unfair practices on such exchanges and markets. 3, to discharge and prevent the use of credit in financing excessive speculation in securities. To compel corporations to furnish adequate information on securities publicly traded in. And 3, to control unfair use of information by corporate insiders. Dude, they're like violating all these right now. Right? That's the market. To prevent unfair practices, which is what they do with short selling. To discourage, to prevent the credit financing excessive speculation, which is what they're doing. And to compel corporations to furnish adequate information to publicly. These people are nuts. The Fair Labor Standards Act, Wage and Hour Act, passed in 1938, fixing minimum wages and maximum hours for employees engaged in interstate commerce or in producing goods for interstate commerce. National Labor Relations Act, 1935, designated to safeguard the right of labor to bargain collectively. Congressional powers invalid exercise. Two outstanding examples of the invalid exercise of congressional powers are National Industrial Recovery Act, the NRA, passed in 1933. This act permitted trade and industry to police themselves by drawing up codes of fair competition subject to the approval by the President of the United States. The act was declared unconstitutional because it delegated legislative power. I was going to say that. Legislative power to the executive department, and 2, it sought to regulate business, not truly interstate. The first Agricultural Adjustment Act, passed in 1933. Now they're called the first AAA. This act sought to restore the farmers' purchasing power by adjusting production to demand and compensating farmers who cut down their crops out of a fund raised through taxes on processing the farm product. The act was declared unconstitutional on the following grounds: farming is not interstate commerce, and 2, the tax was not collected for government support generally, but took from one group for the benefit of another. And 3, the act invaded the reserved rights of the states. The second Agricultural Adjustment Act, however, which omitted the processing tax and restricted marketing of farm products to a volume determinable by the Department of Agriculture, was upheld. They failed once. They see what they did that's unconstitutional, and they go and fix it. Limitations on congressional powers. The Constitution of the United States imposes specific limitations on congressional power. Congress may not suspend the writ of habeas corpus, take away the property of a person condemned to death, bill of attainder, pass criminal laws to govern acts committed prior to the enactment of the law, ex post facto laws, tax exports, give preference to any domestic port or compel vessels doing an interstate business to pay duty, grant titles of nobility, An office holder may not accept any present office or title from any foreign land or its head without the consent of Congress. Limitations on states. In addition to prohibitions in the respect to attainers, ex post facto laws, and titles of nobility, no state may make treaties, issue money, pass any law impairing the obligation of contracts, lay import or export duties, tax marine tonnage, keep armies or warships in peacetime, or engage in war unless actually invaded or in imminent danger. Expansion of Commerce Clause. Most debated, perhaps, of all federal powers is that embodied in a clause which gives Congress power to regulate interstate commerce. Both words, commerce and interstate, have been broadened considerably by judicial interpretation, and the main one is going to be the insular possession cases of 1901, and that's Downs versus Bidwell, and what is that? LaSalle versus Bidwell. Commerce. It was originally contended means trade. Chief Justice Marshall broadened the definition to include not only merchandise carried in trade, but the carriers as well. From carriers to merchandise, the interpretation broadened to carriers of passengers, later to the transmission of intelligence or electric power by wire, including telegraph, telephone, and power companies, and still later to motor transportation, radio broadcasting, and airplane travel and transportation. The Supreme Court even defined news of commerce when it held that the National Labor Relations Board could order the Associated Press to rehire employees who had been discharged because of union activity. The interpretation of commerce is no longer confined to trade, transportation, or the transmission of power or intelligence. Congress is held to have power to regulate all forms of interstate business and industry, to pass antitrust laws, to legislate on trademarks and trade names, to quarantine cattle, prohibit interstate traffic in lottery tickets, or the shipment of mislabeled food and drugs, and to legislate on all phases of labor directly or indirectly concerned with interstate business. Hours, wages, fair practices, and collective bargaining. This is a big little paragraph right here, because it tells you the potential activities, right? So, like, if you're subject to some federal law or regulation, you're doing one of these activities. Especially look at the bottom one, with all phase of labor, directly or indirectly, concerned with interstate business. But, whose minimum wage are you getting paid by? Who's, collective bargaining thing, you know what I'm saying? Who's protecting you, I guess, while you're at work? That's what really it is. What protections and rights is this government offering you for you being able to work there with the use of their social security number and pay into their schemes? Interstate literally means states as distinguished from intrastate. Means states, plural. And intrastate, which means within a state. So between states and within a state. The original concept of intrastate commerce was that of commerce inside the borders of a single state, as opposed to commerce between the states. The expansion of the interstate concept is illustrated in the following cases. The Supreme Court voided an act of Congress which sought to prohibit interstate shipment of goods made in factories employing child labor. Congress said said the court, had no such power under the Commerce Clause. But the United States versus Darby, the Supreme Court, in approving the Fair Labor Standards Act, held that if a person produced goods for interstate commerce, he was subject to federal regulation, specifically reversing its prior decision, Hammer versus Dagport. So what is that, 31 years later? Something like that. Not even that. 27. So Congress voided an act that prohibited interstate shipment of goods made in factories employing child labor. And in this case, in approving the Fair Labor Standards Act, held that if a person produced goods for interstate commerce, he was subject to federal, which is true. Well, it's all about when you're in public, right? Interstate commerce is public. It's public meaning it's part of the delegated powers you gave them. That might be a good case to read, though. This right here. I'll highlight that. Same thing with the court case. That's worth taking a look at. In the NRA case, Schechter Poultry Company Corporation versus U.S., decided in 1935, the National Recovery Administration sought to fine dealers for violating the poultry code. The poultry was slaughtered in New York, sold to retailers in New York, and resold to consumers in New York. But the business had a competitive influence outside New York. The Supreme Court has, as already noted, invalidated the act, not only on the ground that it delegated legislative power to the executive department, but also on the ground that it sought to regulate intrastate commerce. Indirect effect on interstate commerce was held immaterial. So this right here is important right here, what they just said. Right? For those of you who's paying attention. Right? Up here they just told you that, no doubt, right, if you're producing goods for interstate commerce, he was subject to federal regulation, right? So, like, that's a given. You're in their house, messing with the public, you're going to be subject to their regulations. Maybe not direct control, right, because of the type of entity you're functioning in, right? But nonetheless, some type of regulation. But down here, they just showed you that this company, they slaughtered it in New York, sold it to retailers in New York, and ultimately it was resold to consumers in New York. This competitive business stuff outside New York don't mean shit, because it's not the business who's sending its business outside New York. So the Supreme Court invalidated the act, not only on the ground that it delegated legislative power to the executive, but also on the ground that it sought to regulate interstate commerce. This is private right here. You might get taxed locally, but not federally. There's no federal government involvement here. And there's multiple ways to get the government involved, the federal government. Not only through the activity, but the entity that you use. Those are things you gotta consider. Indirect effect on interstate commerce was held immaterial. But in U.S. v. Because today they have it right where you have it, like the outside effect, right, to outside of New York meant nothing, right? But say in another scenario that he was advertising in, say, Chicago, that company. He has entered interstate commerce. You know what I'm saying? He put his product on interstate lines of transmission for advertisements by leaving his state and doing it somewhere else. Those things are important to understand and what it means to be public and private. You don't want regulation. You don't want them in your house, right? You don't want to be taxed as much. Okay, well, you have to minimize your exposure and accept only what you're willing to accept in the public. Whatever liabilities those activities bring. Indirect effect on interstate commerce was held immaterial. But in the U.S. versus Wrightwood, the Supreme Court held that milk processed exclusively in Illinois, in competition with interstate handlers in that area, indirectly affected interstate commerce and was therefore subject to federal regulation. That's crazy. Held that milk processed exclusively in New York, in competition with interstate handlers, whatever that means. That just sounds fucked up. Am I going to read all these? If there's more decisions, interstate commerce as follows. NLRB and Feinblatt, 1939. Small New York clothing manufacturer bought all his raw material in New York and sold all his garments in New York to a New York concern. Concern just means business. Which shipped to customers, some of whom were outside the state. The court held that the clothing manufacturer was subject to federal labor regulations because labor disputes might lead to strikes. Strikes might reduce output, and reduced output might curtail interstate shipments. Wow, that's a far reach. So it's like the person you're selling it to, that person chooses to do interstate commerce. And because of that, that's crazy, dude. 1939. I would like to see if these cases were overturned. Especially these were the beginning, the real beginning one, when they really started using these. I want to look this case up too. Number 12. But all these for sure. Wickard versus Filburn. A small farmer exceeded his wheat raising allotment under the Agricultural Adjustment Act by 12 acres, for which he was assessed. To the farmer's plea that his wheat raising was for local consumption, the Supreme Court replied that such consumption might affect interstate commerce, but they're not giving the reason here. A small farmer exceeded his wheat raising allotment. So whatever makes him subject to this act, Agricultural Adjustment Act, right, by 12 acres. So whatever makes him subject to an allotment under this act. The Supreme Court held that the wages and hours of porters, elevator operators, and night watchmen in the New York City loft building were subject to federal regulation under the Fair Labor Standards Act because, one, some of the tenants were engaged in interstate commerce. Some of the tenants? Think about what they're saying here. These are workers in a loft building. And because of some of the tenants because some of the tenants were engaged in interstate commerce. Other decisions which have broadened the scope, right? So these are expansive things that are being decided here on this power. Some of the tenants were engaged in interstate commerce, hence, number two, the building employees were engaged in occupations necessary to the production of goods in interstate power. What the fuck? How the fuck can they do that right there? I gotta go look these cases up. See if they've been overturned. This is what you would do, shepherdize these. Is all the, like, you'll find a book that has all these court cases that have expanded or diminished the Commerce Clause power. But man, like this right here, this is like the long arm of the law, right? Because some tenants of a loft building were engaged in interstate commerce, the building employees were engaged in occupations necessary to the production of goods for interstate commerce. That's crazy. This right here is nuts. What is that, 15? You guys understand what I'm saying here, right? What this fucking case is saying. Now, I see this too, because there's another court case that I told a story on. The guy, he just called him an American citizen, right? And he was working for a European corporation as a seaman on some boat near India or something. The courts here ruled against him on income taxes. And the way it went is that even though the source of his money was from a foreign corporation, the foreign corporation, its majority source of income was from a source within the United States. So they got him based on the company he worked for, that their source of income is from within the United States. So it's like looking at that principle or whatever that's called, right? But we'll look at this, assuming tenants that their income, because it's interstate commerce, is within the United States, because you're looking for the principle, not the fact that they're just saying it, right? You're looking for the principle that might allow this to happen. If the tenants were, their income from within the United States to such an extent that their employees, man, it's crazy. Their employees were engaged in occupations necessary to the productions of goods for interstate commerce. These cases are going to bother me right here because that looks like they're just walking all over. Constitutional guarantees and safeguards. Embedded in the Constitution are certain fundamental guarantees, safeguards, and limitations, serving as a bulwark to protect minorities against oppression. These include personal, civil, and political rights and safeguards, personal liberty, personal security, freedom of religion, freedom of speech and the press, right of assembly and petition, equal protection of the laws, and the prohibition of special privileges, immunities, and class legislation, which they violate all the time. Specific guarantees affecting property rights, including the provision against impairing the obligation of contracts and certain restrictions on their exercise of such dominant powers as eminent domain and taxation. Liberty and security. Reference has already been made to the natural rights of personal liberty and personal security, including the safeguards of bail and habeas corpus. The guarantee of personal liberty implicit in numerous provisions of the Constitution is specifically mentioned in the Fifth Amendment, which provides that no person shall be deprived of life, liberty, and property without due process, and the 14th Amendment, which reiterates the prohibition to the state. So understand that's what the 14th Amendment did. And there's a lot of court cases before the 14th Amendment, right? That the courts were already holding this portion of the 14th Amendment, the due process clause, right? That they cannot violate the states can't violate your fundamental rights either. Meaning your other liberties and all that stuff. So it's always been a thing. The 14th Amendment just enshrined it on paper. That prohibition, right? Oh, that's in the Fifth Amendment, right? Applies to everybody. But because it was never written in the Fifth Amendment, even though the courts were ruling that it applied to the states, well, the federal government went ahead and did it in the 14th Amendment, which changed nothing. It just established it on writing. Personal security is safeguarded by the following restrictions: criminal prosecution. I'm not going to read them. So criminal prosecution, double jeopardy, self-incrimination, cruel and inhuman punishments, excessive fines, and bail are prohibited by the Constitution. Ex post facto laws, any law which imposes punishment for an act not punishable when committed, or new punishment for an act in addition to that enforced when the act was committed, is forbidden. Freedom of religion. The first of the 10 Amendments, Bill of Rights, provides Congress shall make no laws respecting an establishment of religion or prohibiting the free exercise thereof. The 6th article of the Constitution further provides that no religious test shall ever be required as a qualification to any office or public trust under the United States. Freedom of speech and the press. The First Amendment provides that Congress shall make no law abridging the freedom of speech or of the press. No law may be passed which limits our right by the spoken or written word to criticize any public or private act. On the other hand, as the Supreme Court observed, freedom of speech and the press does not permit the publication of libels, blasphemous or indecent articles, or other publications indecent to public morals or private reputation. Right to assembly. The First Amendment guarantees the right of any and all persons individually or collectively to apply to any officer or department of government for relief for the redress of grievances, free of all penalty for having sought or obtained it. Equal protection of the laws. The 14th Amendment provides that no state shall deny to any person within its jurisdiction the equal protection of the laws. It is a denial of equal protection to pass legislation that discriminates against some persons in favor of others. In this sense, persons includes corporations. The law may discriminate, however, where real differences exist, such as differences in age, sex, professions, and trade. So you guys understand that, at least in this portion, where they're saying the word persons did not only mean corporations. But the law may discriminate, however, where real differences exist, such as differences of age, sex, professions, and trade. Well, at least for this part, it did. Because the due process clause applies to everybody, natural and domestic. Corporate. Privileges, immunities, and class legislation. The 4th article of the Constitution provides that the citizens of each state shall be entitled to all privileges and immunities of citizens of the several states. Now, you guys understand, they said 2 citizens here, right? The citizens of each state and citizens of the several states. One of them is state, the other one is federal. This right here. This is a citizen that the federal government protects. And it's all pertaining to the specific rights and whatever else that apply to this class of citizen. That's what the federal government protects. For example, a state law giving priority to its own creditors is void. The 14th Amendment further provides that no state shall make or enforce any law which shall abridge the privileges and immunities of citizens of the United States. Hence, no statute may prevent a citizen from passing freely from one state to another or from doing business in any state other than its own. And here's a little extra. Who are citizens? Persons are citizens of the United States if they are 1. Born in the United States, or 2. Born abroad of parents who are American citizens, or 3. Duly naturalized. Persons may be naturalized A. by personal compliance with civil naturalization laws, including 5 years residence, declaration of intention, and oath of allegiance. B. by parents' naturalizations, or C. by military service in the armed forces of the United States. Formerly, a female alien acquires citizenship upon marriage to an American citizen. Under the Act of Congress of 1922, as amended in 1930, 31, and 34, citizenship is not acquired by marriage. But if an alien spouse is otherwise eligible, he or she may become a citizen upon full compliance of the naturalization laws without declaration of intention, and upon 3 years residence prior to filing a petition instead of a normal 5-year period. So who are they talking about here? Who are citizens? You have 3 here at least. Citizens of the states, citizens of the several states, citizens of the United States. It's a different hat, man. That's all it is, different hat. Here, corporations are not included within its constitutional provision. The provision relates to citizens. Although corporations have been judicially declared to be persons, they are not and cannot be citizens. Hence, any state may refuse, limit, or regulate the right of corporations organized in other states to enter that state and conduct business therein. This is a given here. And I keep repeating it. And now this is a book that someone else is encouraged for people to read. Stating the same things that I've been saying about the United States citizenship, its corporate capacity, and all that other stuff. Who does it apply to? Who cannot use the privileges and immunities? I'm surprised there's not annotation, because there is a court case. There is a court case, and it's an Illinois court case. That at least the Illinois court case recognized that corporations are persons. So if your Social Security account number is a corporate entity and they're considered persons, and citizenship is not what's screwing you, it's this person that you're acting under, things might be able to make sense about citizenship. Impairing obligations of contracts, police power. The Constitution provides that no state shall pass any law impairing the obligations of contracts. The provision is directed at state action, including state constitutions and state statutes. It does not apply to Congress. That's crazy. And that's because the way it's written, too, it says no state. Right, and the Constitution says no state. Really? Police power. The constitutional limitation on state impairment of contract obligations is subject to the implied reservation of state sovereignty and all necessary measures to protect it, which come under the general designation police power, or the dominant power of a sovereign government to pass laws for the promotion of public health, safety, morals, and general welfare. Hence, tenement house legislation, sanitary laws, emergency rent laws, and laws fixing maximum and minimum prices for public necessities may impair the obligation of contracts without violating the Constitution. Eminent domain. The right of a sovereign power to take private property for public use is limited by the Fifth Amendment, which commands just compensation to the owner and by due process, which says they could. Doesn't say they can't. They just got to give you a chop. Which provides that no person may be deprived of his life, liberty, or property without due process of law. The power of eminent domain may be exercised by a government directly, as where it condemns property for a post office, courthouse, or public road, or it may be delegated to a corporation or individual together with a delegation of some public duty or function, as in the case of railroad, telegraph, and telephone rights of way. There can be no right of eminent domain unless the purpose is truly public. A little note. I'm not going to read that. It's condemnation proceedings back in the 1930s, or whenever this book was made, 1945 or something. Taxation. The power to tax is essential to the very existence of a state. Hence, taxes may be made with constitutional impunity, cut into property and contract rights, provided their purpose is public and their imposition uniform. A fundamental distinction in taxing powers should be noted between federal and state governments. Each state has an unlimited power to tax, which goes with sovereignty, but federal taxation must be limited to specific purposes delegated by the United States Constitution. Taxes may be collected upon the basis of an assessment, as in the case of real and personal property taxes, or upon the basis of a return made out and filed by the taxpayer, usually accompanied by his remittance. Civil and criminal penalties being imposed for failure to make the return. Many taxpayers are required to furnish complete accounting information, balance sheets, and so on as a basis for tax computation. Taxation must be for a truly public purpose. If the levy is on one group for the benefit of another, the tax is unconstitutional. Due process. All dominant government powers, including the eminent domain, the police power, and the power to tax, as well as all private rights and powers, are subject to the all-inclusive constitutional limitation of due process. Let me repeat that. All dominant government powers, including eminent domain, the police power, and the power to tax, as well as all private rights and powers, are subject to the all-inclusive constitutional limitation of due process. The Fifth Amendment, as noted, provides that no person shall be deprived of life, liberty, or property without due process of law. And the 14th Amendment applies the provision specifically to the states. The term due process has been given widely varying interpretations, but the concept corresponds roughly that of the law of the land. All right, I'm going to stop it for now and do another one. So this will be part 3, because this is like a 90-section thing. So I'm on page section 71 right here. Cut off for now, but I'm going to start on part 3. So hopefully you guys learned something for sure about this terminology with the Constitution of the United States, regardless if you guys don't like it, right? Hearing what he said. The only question that you should be having is, where am I going to go find the information for what this guy is saying can be true or incorrect? That's what I would be saying. And of course, he gives court cases. So, teach their own, follow your path, do some research, and just keep rolling. For now, take care, and hopefully you guys subscribe and like to the Butterfly Monkey Effect channel. Later.